On July 1st, 2023, Florida did something that took a decade of fighting and 3 governor vetoes to accomplish. They made retirement a legal reason to stop paying alimony.
If there's any chance at all that you could someday get divorced in Florida, then you need to hear this. Florida just changed its alimony laws, and this is a major game changer. The old alimony that just ended included options for permanent alimony or durational alimony that could have lasted up to the entire length of the marriage. The paying spouse could have been forced to pay up to 50% of their income for alimony, but not anymore. As of July 1st, 2023, now permanent alimony is gone out of Florida. Durational alimony is now the longest form of alimony that's available in Florida, and in most cases, it's only going to go up to 50% the length of the marriage. The way that the courts determine the alimony amount changed big time as well. The amount of durational alimony is now going to be determined by figuring out what are the reasonable needs of the asking spouse, or what is 35% of the difference between the net incomes of both parties. This is going to put huge caps on the needful spouse's alimony that they can receive in their divorce.
This story didn't get the coverage that it deserved. A few news cycles and it disappeared. But for millions of men, divorced, paying alimony, wondering if they'll ever be free, this is one of the most significant legal shifts in decades. Because in first time, there's a formula, there's an end date. And if you're a man who's been paying for years, or a man who's afraid of what marriage can cost you, this changes the math. Today, I'm going to break down exactly what changed and why it took 10 years and 3 vetoes to get here, and why other states are paying very close attention.
All right, I am here with Mr. Jones, my client in Henry County. We are so excited. He just got awarded the house. He got a great equity split in the house, alimony denied for the wife, and we are so excited. And Mr. Jones, I know it's been a long journey. That's why I'm so excited. Long journey. We got into fights and everything.
Yes.
We got into it, but listen. He listened, he paid attention, and he got the victory. So just whatever you want to say, Mr. Jones.
Thank you, Attorney Herring. Just like she said, I listened, I paid, and she'll tell you I wasn't cooperative at first, but then I realized she's in charge and she knows what she's doing, and she did an excellent job. I am so pleased, so happy, and excited about the fact of what we got. And it's all because of her. I didn't know what I was doing. So thank you, Attorney Herring.
Yeah, and this is a testament. I do love my clients. I do fight for my clients. Sometimes we butt heads. Yeah. It's only because I want what's right for you. And he will tell you he got beyond what he was even wanting, okay?
Yes.
I don't know if he wants me to tell it, but let's just say he got a 70-30 split in the equity in the home where he gets the 70%.
Absolutely.
Okay.
To understand why this matters, you need to understand what the old system actually looked like. Under Florida's previous law, if you were married for what court considers a long-term marriage, typically 17 years or more, your spouse could be awarded permanent periodic alimony. Permanent. That word meant exactly what it sounds like. Monthly payments with no end dates. The only way out was if your ex-spouse married, or if one of you didn't make it, or if you somehow convinced a judge to modify the order based on changed circumstances. That last option never really works. Men would reach 65. They'd worked their entire adult life. Their bodies were breaking down. Their doctors were telling them to slow down. And they'd go to court asking to retire. Many were told no. Under the old system, retirement wasn't automatically considered a valid reason to stop paying. Judges had wide discretions. Some viewed voluntary retirement as voluntary underemployment. The logic was, if you could still work, you should still pay. One Florida family law attorney described the reality this way. Many elderly men were paying alimony out of their monthly Social Security checks. The marriage ended decades ago. The financial obligation never did. And here's what that looked like in practice. A man in South Carolina, where permanent alimony still exists, wrote this in a reform petition. I'm 78 years old and I'm still working because I have to. My body hurts, but if I stop, I can't afford the payments. I've paid far longer in alimony than I ever was married. Another testimonial. My 66-year-old husband has been forced to pay alimony to a woman he married at age 19. They were married 7 years and did not have any children. Since their divorce, his ex-wife has lived continuously with the same man for almost 40 years. The law still demands that he pay her for the rest of his life. 78 years old, body hurts, still can't stop. That was the system. That was what Florida finally changed. Senate Bill 1416 explicitly qualifies retirement as a valid reason to seek modification or termination of alimony. Here's how it works now. A paying spouse can file for modification up to 6 months before their planned retirement date. The court must then consider whether retirement is reasonable and made in good faith. The law defines what reasonable means. Normal retirement age is either what specifies by Social Security, typically 67, or the customary retirement age for that person's professional. That second part matters. A firefighter's body breaks down differently than an accountant. A truck driver at 62 with back problems isn't expected to find a desk job just to keep paying alimony. A correctional officer isn't expected to keep working until their late 60s, when everyone else in their field retires a decade earlier. And critically, the burden has shifted. Under the old system, a man had to prove he couldn't work. Under the new system, reaching reasonable retirement age creates a presumption that alimony should be reviewed.
Florida's alimony reform and what we've seen in the past year, Florida came through and had sweeping modifications to the old alimony law. And specifically, what did it do? Number one, it took away permanent alimony, abolished. No more permanent alimony in the state of Florida. So what have we seen as trial attorneys in divorce in the state of Florida, whether this law has been good for the parties, i.e. the clients, or bad? Well, in general, the intent was it was going to help everybody drive towards resolution early. And why is that? Because the statute set out caps or parameters where now the lawyers are able to tell the parties, hey, here's the max that you could get in court. And what do I mean? Well, specifically, state of Florida said no more permanent alimony. So when a client comes to you, you can say, hey, look, that alimony where somebody's going to pay for the rest of their life until they die or until you remarry is gone forever. So it already plants the seed that that's not going to happen. Instead, Florida put the alimony in steps for duration, and they call it durational alimony, and they did it 3 ways: long-term, mid-range, and short-term marriages. Long-term, you can get alimony up to 75% of the marriage. If you've been married between, you're entitled to 60% of the duration of the marriage. Or less than 10 years, the max that you can get is 50% of the duration of the marriage. Let me give you an example. If you're married 5 years, in the state of Florida, the max you can get is 2.5 years of alimony. Well, good or bad, Rob? That's what the clients asked. What have we seen over the last year? Well, the good part is you're able right up front to say, look, the cost benefit of going forward on a short-term marriage for the max probably isn't worth it, because the judge is going to say, look, I can only give you 2.5 years, and it really narrowed down what the court's going to think. Meaning, hey, if your spouse is offering you 2 years, why go spend tens of thousands for 6 more months of alimony? The bad of the law is that each case is different. You may have, in particular, what we've seen over the last year, let's say very young mothers with very young children. Example, 5-year marriage, but you've got a 3-year-old and a 1-year-old. We have cases where we have a 2-year-old and the wife is pregnant and it leads to divorce. Those situations are horrific, because at that point, the law says no matter what, from purposes of alimony, they're not paying, i.e. the husband in most cases, more than 2.5 years. So that leaves a mother with basically a 3-year-old and a newborn and says, look, in about 24 months, his alimony obligation is gone. Yes, child support's going to kick in, but we're having to tell clients right off the get-go, and in that scenario, you've got to start looking to get self-supportive.
That's the difference between begging for permission and exercising a right. Senator Joe Gruters, who sponsored the bill after 2 previous failed attempts, put it this way: this bill allows both parties to retire with dignity. Dignity. That's what was missing in the old system. The idea that after working your entire life, you've earned the right to stop. But the retirement provision wasn't the only change. Florida also created a formula that replaced permanent with specific duration caps. And these numbers matter because the answer to the question that every man is going through a divorce is asking, how long will this last? Under the old system, the answer for long marriages was often forever. Now there's a ceiling. For a short-term marriage under 10 years, alimony cannot exceed 50% of the marriage length. Married 6 years, maximum 3 years of payments. There's an end date on the calendar. You can circle it. For a moderate-term marriage between 10 and 20 years, alimony is capped at 60%. Married 15 years, maximum 9 years of support. Not ideal, but finite. Survivable. For a long-term marriage over 20 years, alimony is limited 75%. Even after a 30-year marriage, the maximum duration is now 22.5 years. You can do the math on when you'll be free. And the amount is capped too. Payments cannot exceed 35% of the difference between spouses' net income. And they cannot leave the paying spouse with less money than the receiving spouse. That last part is worth pausing on. Under the old system, there was no floor. A man could be ordered to pay so much that his ex-wife had more disposable income than he did. The new law says that's no longer acceptable. These aren't just numbers. They're answers to the questions that keeps divorced men up at night. When does this end? Now, there's an answer. None of this happened quickly. And that's part of the story. The fight to end permanent alimony in Florida lasted more than 10 years. 3 separate reform bills made it to governors' desks. All 3 were vetoed. Governor Rick Scott vetoed. Governor Rick Scott again vetoed. That one got so heated that there was nearly a physical confrontation outside his office. A comprehensive reform finally passed both chambers with strong margins. Governor DeSantis vetoed it over concerns about retroactivities. The advocacy group went back again. They adjusted the language. They built coalitions. The Florida Bar Family section, which had opposed earlier version, came on board. The Senate passed it 34-6. The House passed it 85-31. DeSantis signed it 10 years, 3 vetoes, countless testimonies from men who just wanted to be able to stop working someday. Michael Bowler, chairman of Florida Family Fairness, released a statement. Anything that adds clarity and ends permanent alimony is a win for Florida families. That's what a decade of refusing to give up looks like. Not everyone celebrated. And I want to address the opposition directly. The First Wives Advocacy Group of Coalition of mostly old women who received permanent alimony fought this bill throughout the process. John Killalea, who founded the group, said after the signing, "On behalf of the thousands of women who our group represents, we are very disappointed. We believe by signing it, he has put older women in a situation which will cause financial devastation." Here's what I think is fair to acknowledge. Some women built their financial lives around permanent alimony agreements. They accepted those terms during divorce negotiation, sometimes in exchange for giving up other assets. They planned their retirement around that income. A 63-year-old woman with serious medical condition told reporters that she couldn't afford another legal fight over alimony. That's a real concern from a real person. But here's a counter-argument the reform advocates made. The old system was designed for an era that no longer exists. When permanent alimony were written, most women didn't work outside the home. Divorce often meant financial devastation for someone who had no earning capacity and no path to building one. That's not the modern economy. Women now hold more college degrees than men. Women participate in the workforce at historic higher rates. The assumption that a divorced woman is permanently incapable of supporting herself doesn't match reality for most cases. And the new law still protects vulnerable recipients. Courts can extend alimony beyond standard caps for disability or for when a parent is caring for a disabled child. The goal was balance, not elimination of support. elimination of permanent obligation as the default. There's a difference between helping someone get back on their feet and strapping yourself to them for life. Florida isn't the first state to make this shift. And based off what's happening right now, it won't be the last. Massachusetts reformed in 2011, Colorado in 2013, New Jersey in 2014. The states that still allow permanent alimony as a routine option has been shrinking. After Florida, the list is down to roughly 6. And then there's South Carolina. South Carolina is one of the harshest states for alimony payers in the country. Permanent periodic alimony isn't just allowed. It's the preferred award for longer marriages. The default is forever. A reform movement is building. The Alimony Reform Alliance South Carolina is pushing House Bill 3098. They've been collecting testimonials. The same stories you heard earlier, the 78-year-old still working, the man paying a 7-year marriage while his ex lives with someone else for 40 years, those are from South Carolina. The momentum is clear. State by state, the permanent model is being replaced by something that has limits. Florida proved it could be done. Now others are watching to see if they can do it too. So where does this leave us? For men, paying permanent alimony in Florida under existing agreements, the new law provides clearer pathways to modification. Retirement is not explicitly in the statute. For men divorcing in Florida going forward, there's a formula. There's a maximum. There's certainty. For men in states that still have permanent alimony, you're watching what's possible. The trend is moving in one direction. And for men who's been hesitant about marriage because they've seen what the old system can do, marriage rates have dropped 65% since 1970. And fear of financial devastation and divorce, it's part of that calculation. This reform sends a different signal. There's a cap. There's an end date. There's predictability. This was one of the most significant family law reforms in recent memory. It took a decade of advocacy and 3 vetoes to get here. It barely made a ripple in the national conversation, but it matters. Because the core principle is simple. Divorce should actually end a marriage. Financially, legally, completely. There should be fair support during transition. There should be protection for people who genuinely cannot support themselves. But working until your body breaks down to fund a marriage that ended before your kids were born? That was never justice. That was a trap dressed in legal language. Florida finally said enough. And somewhere right now, there's a 68-year-old man who just realized he might just actually retire. That's what 10 years of fighting was for. This has been your girl, Rene here. I'll see you guys in my next video.